Good afternoon. We're delighted to welcome you to the second of our three-part webinar series. This is designed to provide an overview of key changes in contractual interpretation, contractual notifications and freedom of contract. Today we're examining the importance of complying with contractual notifications, and we'll look at reprioritising compliance with contractual notification requirements. The law rarely stands still, so it's always important to keep up to date with the very latest judicial developments. I would encourage you to sign up and join us for this full series, but all of these webinars will be recorded and they'll be available on our Vimeo site if you'd like to listen again or to share with colleagues. Just before we begin, to minimise background noise, I've placed you all on mute. If you would like to ask any questions, please do so using the webinar chat function, and time permitting, we'll answer some of these at the end. So, I'm Kate Gillis, an associate in our commercial disputes team. I specialise in construction and engineering disputes. I'm joined today by Lee Hurd, a solicitor in the team. Both Lee and I regularly advise on the validity of contractual notifications within construction contracts. I'm now going to pass you over to Lee and she'll discuss the webinar's agenda for today.
Thank you, Kate. We will start today with a brief look at what contractual notifications are and highlighting where they are often found. Then we will move on to discuss what requirements to look out for in order to be compliant with these clauses. After that, we will then discuss the strict approach that the courts take to contractual notices by examining recent cases such as Mullum Construction Limited against FEHB, Crassor Harbour Trust against Mullum, and Bolgheri Limited against vHodgkins. We will also take a more in-depth look at payment notices and consider the current trend and examine a select number of recent Smashandgrab cases. Finally, we will examine what the practical impact of the court's approach to strict compliance with contractual notifications will have on the construction industry. We will then conclude by considering what steps can be taken to minimise any possible negative effect this may have on contracting parties, before having a brief time for questions. I will now hand back to Kate to discuss contractual notification clauses.
So, generally, contractual notification provisions are very important clauses, and despite the fact that they are often overlooked in construction contracts, they're actually very useful. To serve a notice is one of the most common ways to exercise contractual rights. For example, notices are used to extend the term of the contract, to terminate the contract, or to receive payment under the contract. The courts have typically taken a very strict approach to compliance with notification clauses. Generally, if all of the provisions are not complied with, then service of the notice will not be deemed to have taken place, and this could have devastating consequences. It's therefore vitally important that clauses relating to notices under a contract are clear as to what is required for a valid contractual notice. Lee will now discuss what to look out for when it comes to complying with contractual notices.
Thanks, Kate. An example of contractual notifications under one of the standard form contracts can be seen on the slide at the moment. This is FEHB clause 34.1. This clause relates to the notification for additional claims under the contract. I will discuss this clause in a few minutes. So, essentially, a notification clause must include, provide that the notice has to be in writing, be that written or electronic. It should also specify if it has to be in a specific language or if it is a requirement that it must be signed. These requirements are quite logical and understandable for the validity of a notification. However, the level of detail of formal requirements in a notice clause can be quite surprising. These formal requirements will be upheld by the courts. For example, it was said in the famous Money Investment case that if the clause has said that the notice has to be on blue paper, it would have been no good serving a notice on pink paper, however clear the content of the notice might have been. Therefore, ultimately a notice must look the way it is supposed to. It is important to read the contract carefully and assess exactly how each individual notice is to appear. Notification clauses will also specify what information a notice should contain. Because of the important role that a contractual notification plays, these clauses tend to be very specific about what a notice requires to be valid. so it is important to provide all the necessary information asked for. For example, payment applications will often require vouching as evidence of the sums sought. So going back to FIDIC Clause 34, at different stages of the contract, notices may require different types of information to be provided. In Clause 34, the first notice only requires notification that a potential claim exists. However, the second notice requires specific details to accompany this. It is therefore important to be aware that this is a possibility and to read your contract carefully before submitting each notice to see if there's any extra information required.
Notice provisions usually state the place at which the notice is to be served. Now, multiple business addresses are very common nowadays, and an easy mistake to make is to send the notice to the project or the correspondence address when it actually needs to go to the registered office. It is irrelevant that a member of the company or even the person who is meant to be served with the notice has in fact seen it if the notice has been sent to the wrong address. So ultimately it's very important to check which notices are to be sent where. Furthermore, care should be taken to ensure that the notice is addressed to the correct person. If it's served on a different individual than that specified in the contract, this will once again create doubt as to the validity of the notice. The courts have made their opinion on this point very clear, and we'll come back to that a bit later. The notice clause should also specify the method by which a notice is to be served. Service methods such as personal delivery, DX, recorded delivery, airmail, email and fax are all commonly provided for in notification clauses. Specified methods of delivery will also be strictly applied. If service varies from the means provided for, then this will jeopardise the validity of the notification. Something that's important to highlight at this stage is the validity of serving a contractual notice by email. Email is now the most common form of communication between parties to a contract, and it is sometimes assumed that it will also suffice as a method to serve formal notices. This is especially so if discussion about the notice has already taken place between the parties over email, and those discussions imply that the notification has in fact been received. However, if the contract does not specifically provide for email as being a valid form of service, the general rule will be that that is not sufficient to serve a notice only by electronic means. For certain types of notice, it's likely that there will be a mandatory method of service. For example, termination or break notices and other notices to exercise a right. Often, due to the high importance of these types of notices, the contract will provide that they must be delivered by hand or by recorded delivery. This ensures that both parties are in no doubt as to whether the notice has actually been delivered or not. Now, it might seem unnecessarily burdensome on the notifying party. However, if there is a provided mandatory method of service, then that method should be used to uphold the validity of the notice. A time limit is often also provided for. As you can see in the clause on the screen, notice is required within a period of 28 days and then 182 days. It is common again for such time periods to be strictly upheld. Whilst the difference of a day or even a few hours can seem unnecessarily stringent, such a time frame does often perform an important role, ensuring that vital information is passed to the relevant parties at the right time to ensure the project is a success. Whilst adherence to time limits may seem like a relatively straightforward requirement to comply with, there are often specifics, depending on what form of delivery is used, that mean deadlines are at risk of being missed. Parties may choose to specify a time that delivery will be considered to have taken place, for example, between 9 and 5, Monday to Friday, and because of strict adherence to time limits, if delivery takes place at 5:01, the notification may be deemed to have been delivered the following day, with consequences that could be devastating. This is especially relevant in relation to time limits for faxing and emailing notifications. Ultimately, parties should take care to ensure the precise criteria are complied with. As tedious as they may seem, if these are not strictly adhered to, then the notification might not be enforceable. I'll now hand you back over to Lee, who will discuss some case law examples of the Court's strict approach to compliance with notification clauses.
Thank you, Kate. An important case to illustrate the Court's strict approach to compliance with requirements for contractual clauses is that of Muir Construction Limited against Habley. In this case, the contract was a JCT Standard Form 1980 edition. The contractor served a warning notice on the employers seeking payment of £72,000 and £72,700 by an interim payment certificate. As no payment was received, the contractor then decided to terminate the contract. The contractor served notice on the employer to terminate the contract by hand delivery to an employee of the company. Now, clause 28.1 in that particular contract provided for a variety of delivery options, stating, by notice, by registered post or recorded delivery to the employer or architect, forthwith determine the employment of the contractor under this contract, provided that such notice shall not be given unreasonably. The employer therefore contended that a delivery by hand was an invalid form of serving a notice of determination. In that case, Lord Crassor stated that determination of employment is a fundamental step, wholly altering the rights of parties. That being so, it would be undesirable if there were any doubt as to whether the contractor intended to give the notice or whether the employer had received it. The precondition here in question was itself dealt with by provisions which laid down quite precise requirements as to what the contractor must do. It is unsurprising to find that determination notice has to be given in a specified way. The outer house of the Court of Session found in favour of the employer's arguments. Lord Crassor found that the words used in the clause were carefully constructed and intended by the parties to have a precise effect in a carefully structured procedure. He points out that whilst there are many delivery options provided and that they are all means to the same end, he finds it does not appear to me to mean that their inclusion and the adoption of a specific mode is not something which the parties have stipulated for as a necessary part of the procedure. What we can take away from this case is that requirements laid down in notification clauses are taken by the courts to have been negotiated and agreed carefully between the parties. Therefore, the courts will strictly apply any requirements in order to give effect to the notification procedure as set out clearly and agreed in the contract.
Now, another case of note in respect of notice provisions is the Crassor Harbour Trust against Mullum case in 2006. In this case, the court decided that business common sense should also be applied when interpreting contractual notification clauses. The facts of this case were that following an unsuccessful adjudication decision, Mullum decided to serve a notice of arbitration on Crassor. However, the notice served did not comply with several of the requirements of Article 1.3 of the Arbitration Code 1999 as required by the contract. Crassor argued that the contract referred expressly to the Scottish Arbitration Code and that it had been incorporated into the contract in its entirety, including Article 1.3, where the prescribed process for serving an arbitration notice was set out. Crassor therefore sought a declaration from the court that the notice that had been served was invalid. Now, Mullum argued that strict compliance with the provisions of Article 1.3 was not essential to the validity of the notice. The reasoning was that the sample notice in the appendix to the contract did not itself comply with the provisions of Article 1.3. The letter that Mullum had served complied with the appendix example of a valid contractual notice, and they therefore contended that it was effective. So in this case, the judge found that courts should generally interpret and apply commercial instruments in a common sense commercial or business way, eschewing linguistic and legalistic niceties. Where a contract gives one party the right unilaterally to bring the contractual relationship to an end or to alter it in some other way, then that party must, if he chooses to exercise that right, comply with the agreed conditions for its exercise. If strict compliance with a particular condition is called for, then strict compliance will be enforced. The judge then went on to apply the business common sense to the issue at hand, which was whether parties in this case had intended to be bound by the strict conditions of Article 1.3 or whether they had intended to be bound by their own example in the appendix of what a valid notification should look like. He found here that the parties cannot be held to have intended that compliance with Article 1.3 was a formal requirement for the exercise by either party of the power to require that disputes between them be referred to arbitration. Mullum's letter was therefore considered to be a valid notice of arbitration. So although this case isn't inconsistent with the court's approach of strict compliance with requirements to serve a valid notice, it does indicate that they may take a more business common sense view to notifications than they have previously. However, the judge in this case leaves no room for doubt that if a contract asks for strict compliance with the requirements, then the courts will enforce strict compliance with the requirements. I'll hand over back now to Lee to discuss a recent Scottish decision.
Thank you, Kate. In July of this year, we had the case of Bolgheri Limited against vHodgkins. This case confirmed that strict compliance does remain the approach taken by the courts. This case involved a tenancy under the Agricultural Holdings Scotland Act 1991. vHodgkins served a notice intimating that he intended to become a tenant under Section 72(6) of the 1991 Act. Bolgheri challenged the validity of the notice as, whilst it contained all the information required by the statute, it was addressed to Mr. Patterson, who was a director of Bolgheri Limited, rather than the landlord, Bolgheri Limited. Mr. Patterson, despite operating the business from his home and being a director of the company, was not technically the landlord. The landlord was the company. Mr. Patterson acknowledged receipt of the notice and that its purpose was to allow Mr. Hodgson continued tenancy. However, he argued that as it had not been served in the required format, that the notice was not valid. Whilst there is no doubt that the company was aware of the notice, given that it was served on one of their directors at the correct place of business, the court was troubled by a lack of certainty if they were to allow the notice to be deemed valid. In his decision, Lord Brodie Court quoted Lord McFadden in Ben Clough Estates Limited against Scottish Enterprise, an inner house decision, where he stated that he happened also to be a director of Ben Clough and thus acquired knowledge of the notice and was able to react to it. In that capacity, does not, in our opinion, convert a notice given to Bonnytown into a notice given to Ben Clough. Therefore, the court found in favour of Bolgheri, finding the notice to be invalid. Lord Brodie explained that in this area of the law there is need for certainty to the extent that that is possible. Parties need to know their respective positions and thus need to be able readily to ascertain whether or not a notice has been given. The law must therefore provide a bright line test. What we can take from the decisions in all of the cases discussed today is that the courts want to uphold contractual terms, as these have been agreed by the parties. If the courts readily moved away from the precise requirements laid out in contractual notice clauses, this would create uncertainty as to what would constitute a valid notice. Uncertainty in contracts is something that is always considered undesirable. Therefore, no matter how cumbersome or menial a requirement might seem, if it forms part of a contractual notification, then it must be complied with. I will now hand back to Kate, who will discuss notification requirements for payment notices.
Thanks, Lee. I'm going to look now at the recent trend in the construction industry to take advantage of the 2011 amendments to the Housing Grants, Construction and Regeneration Act 1996. Colloquially known as smash and grab cases, there have been a series of adjudications where contractors have been relying on technical errors made by the other party, which is typically a failure in the form or the timing of payment notices, to claim full payment of notified sums where the employer has failed to comply with payment notice provisions. Now, a typical example of the smash and grab trend from this year is Jobey property investment against the Interiors Group. The contract in this case was an amended JCT 2011 design and build, and it required the contractor to submit an interim application for payment, giving their valuation on the 8th day of every month. This would then be followed by a certificate from the employer detailing the sum to be paid. So, on the 7th of January 2016, in response to a request by the employer, The contractor in this case sent an email which attached a breakdown described as being an initial assessment for valuation. This was at odds with the way that previous interim applications had been dealt with, both in the way it was described and also because it was not brought up to the due date, which would have been 8th of January. The contractor argued this was nevertheless a valid interim application for payment. The employer, who had not issued a pay less notice in response, disputed this for several reasons. It said that email transmission did not comply with the requirements for service under the contract, that the email was not labelled as being an interim application, that it didn't state a sum that was considered to be due, and that it was not accompanied by supporting documentation as required by the contract. Now, the judge held that the employer's first argument, which was to reject the electronic transmission of the application, was unfounded. This is because electronic service was not expressly or impliedly excluded by the relevant notice clause, and in any event, the employer had already accepted 6 prior interim applications by email, so they could not now argue that email service meant an application was invalid. Ultimately, however, the judge considered the contractor's email on the 7th of January 2016 was not a valid interim application. The reasoning was that this type of initial valuation had never been dealt with as a valid interim application by the employer before, and it was not sufficiently clear that it was intended to be an interim application because it was not sufficiently unambiguous. So although you can see why the contractor would try to argue that this was an interim payment application, the judge's decision is consistent with the court's reluctance to give effect to ambiguous payment applications that do not strictly comply with requirements agreed to in the contract. Clarity is therefore key. If a notice is supposed to be an interim application, then it should say that that's what it is.
Looking now at another payment case from this year, in the FEHB Structures case, there was a dispute concerning the validity of a payment notice served pursuant to the payment schedule in a subcontract. The subcontract provided for the subcontractor, FEHB, to apply to the contractor for interim payments in accordance with an agreed payment schedule. The payment process was set out in detail in the schedule, which was an appendix to the contract, and this included dates for each step. From March 2015 to September 2015, the dates in the appendix followed a consistent pattern whereby the payment notice and PLS notice were to be served on the same day on or around the 20th of the month, and in any event within 5 days of the due date. However, the dates differed for the process in the month of October. For October, the appendix stated that instead of being due on the same day as the PLS notice, both being within 5 days after the due date and 2 to 3 days before the final date for payment, as it had been for every prior payment cycle, the contractor's payment notice was due on the 23rd of November. The 23rd of November was also the final date for payment. It was 7 days after the due date and was later than the pay less notice date, which is not permitted by the Construction Act. The subcontractor duly submitted its application for October, and the contractor issued its notice on the 23rd of November in accordance with the schedule. The subcontractor argued that the notice was invalid on the grounds that it was late in terms of Section 110A of the amended Construction Act, which states that the date for a payment notice must not be more than 5 days after the due date. The contractor argued that its notice was valid as it complied with the contract and was served in time under the payment schedule. The court held that the agreed payment process and timing were clear from the dates from the first application for interim payment and the consistent pattern that followed thereafter. The dates showed that the payment notice and PLS notice had the same deadline in each month and fell within 5 days of the due date. The court could see no reason why the parties would intend for that consistent format to be varied for October. There was therefore an obvious error in the payment schedule for October, and the contractor's payment notice had been served out of time and was invalid. This decision was arrived at based on a very specific set of facts and has not been especially welcomed due to the uncertainty it raises in circumstances where the contractor or employer complied with the letter of the contract. It is, however, an important reminder to carefully check dates when issuing notices, and if there is any doubt, take the cautious approach by issuing a notice on the earliest date that could be due.
So what is the practical effect of all of this for contracting parties? Well, generally, parties will need to be aware of the rigidity of the notice requirements. This is especially important to keep in mind at an early stage in the contracting process. It's necessary that the requirements for a valid notice are identified, and parties should consider if any of those requirements are not feasible for them, perhaps timescales that can't be met due to internal processes. Once these are identified, it may be possible to negotiate with the other party to remove these requirements and instead put in place a notification procedure that is effective and workable for both parties. Then, once serving the notice, it's always useful to make sure that you read the contract. Might sound like a given, but reading the contract is the best place to start. All the information we've talked about today should be there, and therefore it is a matter of abiding by those regulations. Make sure your notice is in the correct form as prescribed by the contract. Remember the case we talked about earlier, Manai Investments against Eagle Star, that's the pink and blue paper case. It's a good reminder of how specific these criteria can be and that they must be followed. Check that you've included all of the relevant information, especially where vouching is required. Always make sure you have the correct address and name of the person that the notice is to be served on. Make sure you've served the notice by a method that complies with the clause, and it's vital that you're aware of the distinction between discretionary requirements and mandatory requirements. If there are mandatory delivery requirements, always double check that these have been carried out. Lastly, it's important to make sure you always serve your notice on time. Timeframes can be tight, but they do serve a purpose and are usually strictly enforced.
Ultimately, precision is key to valid notifications. If there is ever any doubt as to what would constitute a valid notice, it is important to seek prior advice to sending the notice. This will ensure that all notices will be enforceable, valid, and leave parties with no room for doubt as to whether they have complied with everything under the contract. Certainty as to validity is vital to avoid being forced to enter expensive and timely disputes, especially when it comes to particularly important notices such as payment or termination.
So we've now come to the end of the presentation. We hope it's been useful and interesting. We do still have just a couple of minutes left, so if you haven't already done so, please type any questions into the chat box just now. While you're doing that, I'll take the opportunity to remind you that we have the last of our webinars in this webinar series coming up on the 29th of November. Also, our team regularly produces update articles about relevant or interesting construction cases and updates covering the type of cases we've discussed today. So if you don't already receive those updates, please let us know and we can assure you that you receive them in future. Right, we've just got one question coming up on the board. What should you do if you realise that a notice has been incorrectly served? In response to that, I would suggest that you should take legal advice in these circumstances to see whether you can rectify whatever the problem is in the service. In general terms, the best approach would be to reissue the notice, this time complying with all the notice provisions. That might be more difficult to do if there is a timing issue, for example, but in those circumstances, the best course of action will often depend on the circumstances, on what the notice relates to, as to how significant it is. So you're always best seeking advice if you find yourself in those circumstances. So I think that's the last of our questions. We've come to the end of the time for today. I hope you've enjoyed our webinar and found it informative and useful, and we look forward to welcoming you to our future webinars. Thank you.
Thank you.